Hello everyone, welcome back to my channel. This is Endless Courage. So, I usually explain what's happening in the video with the different hearings. This is a landlord-tenant hearing, but I really like the slowness of Judge Middleton's cases. I like how he handles no-shows, whether it's the plaintiff or the defendant. So just enjoy 44 minutes of just how the courtroom works, and maybe notate if you have, find yourself in a similar situation, how you would go about resolving, your case, and just like the formalities of it. I like how Judge Middleton communicates with like the legal aid and the different lawyers. He's very patient. I've even the next video you're going to see him calling a defendant on the phone because for whatever reason he can't get on Zoom, and so he goes that far for the plaintiffs or the defendants. Well, actually both. So let me know what you think in the comments. Like and subscribe.
There's a camera here somewhere. Where you turn it on at?
The little icon that says video, there's a little video camera with a slash through it, should be down the lower left.
Just touch it.
Yes.
Come in.
Kind of turn the camera on.
Yeah, I've got it.
Oh, okay.
All right, we'll do the best we can. Good morning, Miss Richmond. Oh, there
Good
you go.
morning.
Didn't realize you were here. Thank you.
You're welcome.
It is time for our landlord tenant docket. It's 9:59. Terry Richmond is here on our first case morning at 10. Belinda Weaver is here on our next case, and we'll address that one in just a moment. Let me get my date up here. 29. All right, our first matter, it's 10 a.m., is Terry and Larry Richmond versus Frank Poway. This is a property on 4th Street in Three Rivers. The file is 251394, filed as a demand for non-payment of rent. Seems like we had one of these just a few months ago with this defendant. Ms.
Yeah.
Richmond, what's the status here?
Right now, he owes $945.52 in rent. Court costs of $116.66, with a total of $1,062.18 through July.
That's what I want to know every time. How much? How much are the costs? And nobody does it. Hey, the lawyers don't do it. I know, you lay it right out clearly for me. Now, Mr. Poway was served by attachment. Is he still?
He's still there. He told Lydia he was going to pay and stay. He told Larry he was moving. So I don't know. He's a mess.
All right. Well, somehow today I spread your cases out. I apologize. You got to come back a little later, but
yeah, that's all right.
This case is by attachment, so I can't do a default. So let's look at our time here. I'll try to put your new cases together. How about if we continue to Tuesday, July 29th at 9:30?
Okay.
You mean I have to come back?
No, she's not talking to you.
No.
All right, Miss Richmond, I'll see you a little later.
Yep, 11:10, I believe.
All right, I'll see you then. Thank you.
All right. Thank you.
Yeah, but there's also with.
All right, Miss Weaver, I'll be with you here in just a moment. I was hoping maybe somebody else would show up, so I would have to do the advice of rights twice, but let's go ahead and do it now. Our next case is Washburn Lake versus Melinda Weaver. Washburn Lake is now known as Neighbors
Yeah.
of Washburn. Miss Weaver, you're here on a landlord-tenant case. And as a defendant in a landlord-tenant case, they're asking you to pay rent. You have certain rights. Let me tell you about those now. As a defendant in a landlord-tenant proceeding, what have you got? Yes?
You can't do this to work.
Tell them to come back at 11 o'clock. Or I'll call him. As a defendant in a landlord-tenant case, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. That's why you're in the conference room rather than bringing you right into the courtroom. The legal aid attorney hopefully will be here with us. And she can be available for consultation using the Zoom. So that's why you're there. I'm not afraid to have you in the courtroom, look you in the eye. You have a right to a trial by a jury or by the court. You have a right to have the matter heard here in St. Joseph County where the property is located. If you do wish to have a jury trial, you must tell me at this first hearing and be prepared to pay the $50 jury demand fee. Or file a written demand within 5 days unless the judge waives your fee for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, that's what this is. You may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, housing assessment and resource agency, that's Neighborhoods Inc. Or if you're a veteran, you may be eligible for veterans benefits. You do not need a judgment against you to receive this help. A copy of the summons and complaint is sufficient. You've already received that. You may be able to reach an agreement with the landlord by going through mediation or community dispute resolution. If both parties are interested, the court can set that up. You may be able to reach an agreement with the landlord. It means the case would be dismissed, in which case we would accept for filing what's called a conditional order of dismissal. Now, the plaintiff isn't here yet, Ms. Weaver, but I have a question. I don't have a copy of a lease. Do you have a lease?
No.
And it says that this rent is $385 per month. Is it lot only?
Yeah, just lot rent. I own the trailer.
Nothing that they said that you haven't paid rent since the
All right.
March is here and.
I'm gonna put you in the waiting room. Don't go away. I'm waiting for the lawyer to show up. Plaintiff. Who is on the Samsung phone? I can't identify you. Is it?
My name's Donna College.
All right.
I got on a little too soon. Mine's not until 10:20.
That's fine. Let me give you a name. College, Collige. All right, Miss College, stick around. You might learn something. All right,
Okay.
Nicholas Gordon Sanford of the Palitz Law Firm is here right on the tick at 10:10 for our two Washburn cases. Mr. Gordon Sanford, we advised her of her rights. And we determined that she has no lease and that this is lot rent only. Hxllo law firm does a lot of landlord tenant work around the state. There's a debate on whether you can even do this. It's filed as a demand for non-payment of rent in a mobile home case with lot only. The only mechanism to do this is the just cause termination of a mobile home tenancy. And so this issue was raised several times, and we spent a long time on it at the all judicial conference in Detroit in May, with about 150 district judges in the room. And the answer is nobody knows the answer. But it doesn't appear there's any legal mechanism for doing this. But so help me out here. There's no lease. How do we know that the rent is $385 per month?
Your Honor, I'm going based off of, the ledger that was provided for me or provided me by my client. It shows a past due amount of $2,187.54. And Your Honor, I believe under the Summary Proceedings Act and the 7-day demand for non-payment of rent, it does not preclude landlords from seeking or proceeding without a just cause and just under the non-payment of rent actions filed. I believe our office has filed several briefs in support since the meeting that took place in May to the district court judges outlining the difference between proceeding on a non-payment of rent action in light of the just cause statute.
All right, well, I've never seen the brief, but let's assume, so we've got 2,187.54 through June.
Through July, Your Honor.
What are our court costs here?
Court costs would be $197.54, and I apologize, Your Honor. Rent to retain is $1,990 with cost of $197.54.
All right, now speak up.
All right, give me that again. What is rent through July?
Rent, Your Honor, is $1,990.00.
All right, costs are $197.54, so we have them lumped together. So rent and costs through July are $2,187.54. All right. Miss Weaver, what's your position here?
About the
I
$1,120 check.
a check for $1,100 and some dollars. And then I also have a receipt where I had a money order that I sent back in March of the $385, which they say I did not pay.
The eviction notice says that she hadn't paid rent since.
All right, stop, sir. Stop. Unless you have a law degree, you can't represent her or speak on her behalf. You can certainly be there. But all right, so first of all, Miss Weaver, do you dispute the amount?
Yes.
And you indicate you paid $385 in May,
March,
and $1,100 on July 3rd.
Yes.
And then, all right, this other check is dated 8/3, but it isn't cleared yet. So
No.
you contend that you paid $350, $385.
I paid $385 every time,
All right, in
not
March,
$350. They increased it.
$385, and then you've got a check from July 3rd that shows you paid $1,120.
Yes.
No one is here from the park, and it would be helpful if they were.
Well, somebody cashed it because my money disappeared out of my bank account.
All right, just a minute.
Your Honor, if you would give me just a brief moment to reach out to my client to allow them the opportunity to appear via Zoom to go on this matter, because I do see the payment made on March 10th, 2025. However, I'm not showing any payment received since then, Your Honor.
Okay. All right. Yeah, go ahead. We've got another one coming up in a minute.
Okay, it should be quick, Your Honor. Thank you.
Miss College, can you hear me?
Yeah, I can hear you, hon.
All right, I'm gonna take a minute while he's doing that to advise you of your rights. Our case is coming up here in a minute. The esteemed Ryan Buckland is here on behalf of your landlord, but while we're waiting, let me tell you what your rights are. As a defendant in a landlord-tenant proceeding, including non-payment of rent or termination of tenancy, well, let me see who this is.
It's a non-payment of rent, Judge.
Yes. I've got it here. She's applied for assistance, but I've got someone else that's come in by telephone. I'm gonna just have to eliminate that. Who am I speaking with? 257-1078.
Cassandra.
Cassandra Strasser?
Yes.
All right. All right. And here's Mike, who he is. Someone's logged in as Mike. What's your name, sir?
Yes, you can hear me?
Yes.
Okay, I'm Michael Mullet.
All right. You're a plaintiff. All right, Ms. Strasser and Ms.
Yes.
College, advise you of your rights. You're each tenants in a landlord-tenant proceeding, and your landlord has filed a lawsuit either asking you to move or to pay the rent. You have the right to obtain counsel in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. Normally, a legal aid attorney is here with us, but she's not here today, probably because I set this on a Wednesday and she's in demand somewhere else. But we gave you the number on how to contact legal aid, or you can seek other legal advice. You have the right to have the matter heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at this first court appearance or make the demand in writing within 5 days of this date using the jury demand form. Pay the $50 jury demand fee unless the judge waives your requirement to pay the fee because of your inability to pay. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or a federal veterans program if you are eligible. We sent you that information all with the packet. You do not need a judgment against you to receive help from the places listed above. A copy of the summons and complaint are sufficient. You may be able to reach an agreement with your landlord by going through mediation. If both parties are interested, the court can set that up. You may be able to reach an agreement with the landlord. That means the case would get dismissed, in which case we would file a conditional order of dismissal. Mr. Borden Sanford, while you were doing that, I used the opportunity to advise those of their rights. I don't like this case much. There's no lease. The landlord's not here. I'm not sure you have the authority to do it, but here we are. So, and now the tenant claims that they paid some money that doesn't seem to be accounted for. What can you tell us?
Your Honor, I was unable to get a hold of my client. Actually, they are calling me back right now. Would you mind just giving me a brief moment if that's okay?
Yeah, I'll skip ahead to Mr. Buckland's case.
Thank you. Thank you, Your Honor.
All right, Mr. Buckland won't mind. So let's set the two Washburn Lake cases aside for a moment. And we will address Michael Mullet, who is present, versus Donna College. This is a property in White Pigeon. This is a demand for non-payment of rent. and the defendant has asked for some financial assistance. Mr. Buckland, what's the current arrearage?
Current arrearage is $5,764. And then I show court cost of being $104.10 plus the statutory attorney fee of $75 would make it $179.10. So that added together is $5,943.10.
Ms. College, that's a lot of money.
Yeah, it is.
I see that you've applied for some financial assistance. You're considerably behind on your rent. Who have you asked for assistance?
I've done DHS and Neighborhoods Incorporated. And my boyfriend's sister's was helping me out some.
All right, the law requires that I adjourn this at least 7 days. In a case where they've actually filed the request for assistance, I have to adjourn it 14 days, which is good because I have to bump this out to August 29th, excuse me. That's a Tuesday. Mr. Buckland, that's an odd date for us to do cases. But I've set it in the middle of my vacation to come in and try to stay on top of my landlord-tenant docket. Are you available Tuesday, July 29th at 11?
Yes, I am.
Now, Miss College, you're way behind on your rent. I've adjourned it 15 days, because when you file this application proof, we're supposed to adjourn it 2 weeks. Mr. Mullet, we're sort of all stuck with the change in the rules. But if he gets what they ask for, unless you pay the rent within 10 days of July 29th, you're subject to being evicted. That would be August the 8th. And you have to pay the entire amount. Partial payment will not cure the writ of eviction. So if you owe, and to further complicate things, when we get to August, another month's rent is going to be due, which is, so add $750 to the $59 that you owe. Unless you pay the entire amount, you are subject to being evicted, meaning you'd have 8 days or 10 days from the hearing to move. So it looks like rent has not been paid here in quite a while. February, I think is what my note said. January. Paid through January. So starting in February, you haven't paid any rent. So unless you can catch it all up, you're going to be forced to move somewhere else. Have you made any provision to try to find another place to move to?
Yeah, we're looking.
All right. Well, let me repeat, I'm going to continue this matter until July 29th. That's a Tuesday at 11 a.m.
Okay.
And if you can pay the rent, great. If you can't, you may be compelled to move 10 days after July 29th. My advice is always the same. Stay in contact with your landlord. Let him know what your intentions are. And let me tell you this also. If you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving.
Okay.
All right, do you have any questions?
Not really.
All right, thank you. You're good to go.
Thank you.
Thank you, hon.
Thank you, Mr. Mullet. Mr. Buckland, I'll see you next time. All right, let's go back to the Washburn Lake cases. Let me remove Mr. Mullet. We were addressing file number 251158, Washburn Lake versus Weaver. Council contends that the rent through July is $1,990 plus costs. He was going to check with his client. Mr. Borden Sanford, what can you tell us?
Your Honor, I have my client, the manager of the community, Ms. Daler, in the Zoom as well, so she'll be able to confirm. And according to our ledger, which is what we base, this action on, no payment, at least on my end. Ms. Daler, can you confirm if there has been the alleged payment of $1,120 made?
No, the last payment I showed that was received was for $385 in March.
All right, so this calculation includes the March payment?
Correct.
Yes.
And what the defendant filed with that is a money order receipt, which shows it was cashed. That with the, yes, with the July, there's no money order receipt. It's simply a personal check dated July 3rd. So maybe it hasn't cleared yet. At any rate, the law says I have to continue this matter. And we're going to continue both of these. Oh, I did for 9:30. Mr. Borden Sanford, are you available Tuesday, July 29th at 9:45?
9:45. I believe I am, Your Honor.
All right. Now, in the meantime, Ms. Weaver.
Yeah.
See whether this check clears. 1,120. You indicated you intend to pay more.
Yes.
This is actually a 15-day delay, which I normally don't do, but I'm on vacation. So we're going to go to July 29th. If you've paid everything, then you're squared away, but you need to get caught up. And if you haven't paid everything, we'll discuss it further. We'll see whether this $1,120 check clears. And Mr. Borden Sanford, I'd like to see the brief that your office did on that topic.
Okay, I will make sure you file that, Your Honor.
The consensus was we either need a Court of Appeals decision or a change in the statute to allow this, but we'll see. And if we get to this point, your lot rent is unpaid, so your mobile home would be terminated. And so it's a screwy posture that we're in right now. Under the just cause termination, you would have 10 days to move and 90 days to move or sell the mobile home, but it's less clear in this circumstance. My hope is, Ms. Weaver, that you can get all the rent paid and keep your tenancy.
Me too.
All right, do you have any questions?
No.
Ms. Daler, let me ask you a question.
Yes, sir.
Why don't we have a lease in these cases?
This company was the company I work for would purchase this community in October. They're currently working on getting new leases for everyone. They just haven't yet.
Well, that would be very helpful if they did.
Yes, sir.
Okay. All right, Ms. Weaver, I'll see you on July 29th at 9:45.
Okay, thank you, sir.
Thank you. All right,
Can I
we
leave?
have given, yes. I'll put that in the waiting room. I've got a number of other people show up for their hearings. We're at the 10:15 hearing, so we're behind schedule, but we had to wait for some matters. This is 251359 LT Washburn Lake versus Cassandra Strasser. Cassandra Strasser is here by telephone only, which is not ideal.
I'm sorry, Your Honor. I tried to get online and I couldn't, and I was running late, so I just called the number.
Well, it's our last resort, so you are here. Yeah, people practice like 1 minute before showtime. What we prefer is if you can't do it, you actually come live to the courthouse like the last lady did. But let me get everybody here. This is a similar situation. It's lot only. There is no lease, and they're asking for payment of rent rather than file under the just cause mobile home statute. Mr. Borden Sanford, what's the arrearage here?
Your Honor, I'm showing, past due rent of $2,559.43, court costs of $197.54, bringing the total to $2,756.97, Your Honor. And I will note that under MCL 600574141, it indicates circumstances which a landlord is entitled to recover possession of the rental premises through subsections A through H.
All right, that's in your brief?
That is in my brief, Your Honor.
All right, well, when we see the brief, we'll explore that further. Ms. Strasser, what's your position?
I have tried to contact her by phone number and the call never goes through. She sends texts periodically, but I have money orders dating back since March of this year that I have paid my rent on time since March. And I knew nothing about any of this eviction until the gentleman showed up on my door to deliver papers.
Well, let's take a look at the pleadings.
And Your Honor, I will note the last payment received was for $410 on April 7th, 2025.
All right, it says rent is paid through November. So this would be January or December forward. And the plaintiff says last payment received in March.
April, Your Honor, April 7th.
All right, sorry, yes. That's why it's problematic, Ms. Strasser doing this just by telephone, because I can't see anything that you have. The law requires that I continue this matter, and I'm going to do that. I'm going to continue it until July 29th. (2025) at 10 a.m.
Okay.
And let me tell you what the deal is. If you pay this rent, you don't need to come. If you don't pay the rent, you're unable to pay it. And you have to pay the entire amount. Partial payment does not prevent the writ of eviction. Then you could be subject to being evicted 10 days after our next court hearing. Our next court hearing is July 29th. Unless you pay the entire amount of rent, by that date, you could be subject to being evicted 10 days later, which would be August the 8th. And that's a Friday. So if you've got some money orders that you contend should be applied to the rent, take them into the manager and compare your accounts to see if we can get to an account. But according to Mr. Borden Sanford, no payment has been made since April of 2025. So that leaves May, June, July, and soon to be August, probably some other months behind it. So if you have those receipts, share them with your manager, or certainly bring them when we come to court on July 29th. And Mr. Borden Sanford, if you give me the brief in that case too.
I will, Your Honor.
Because then the question is, what's the remedy? I'm evicting the mobile home, so the landlord has to move it. So we'll cross that bridge when we get to it. But Ms. Strasser, I will see you in 15 days on July 15th at 10 a.m. If you can't Zoom in, please come here to the courthouse and I'll speak to you face to face. All right. Do you have any questions?
I have a quick question, Your Honor. How would you like for my office to submit this brief in support?
Well, if you've already written it in other cases, just put this caption on it and send it for filing in each one of these cases.
Sure.
Because we asked, has anybody had a brief on this? We had two of our judicial experts in landlord tenant, Judge Reeds and Judge Buchanan, and we had a lively discussion for more than an hour without solving the problem. So I'm interested to see if you've got some authority, and then I'm interested to know what you're asking for as a sanction.
All
right. Anyway, we'll take another crack at this. Maybe they'll pay the rent. And hopefully it's been October to July. They could get leases with these folks and make sure things are more clear.
Will do, Your Honor.
All right.
Appreciate the
All right. Thank you.
Thank you.
All right. At this point, we're 9 minutes behind, which isn't too terrible. We did skip ahead for a case. We've got some other people joining us, but George and Rita Phillip are here. I like the glamour shot better than the one with George in it here, but we will address this. And Attorney Richard Herman is here from Bingham Farms.
Yes, sir.
You ever been to Centerville?
I have not, sir.
Well, you're missing out.
There's lots of time left.
You ever been to Mendon?
I have not.
Well, you really are missing out. But I know your clients, but I don't feel I need to disqualify myself in this matter.
Okay.
It does not appear that Autumn Cheeseborough is here, and I couldn't tell whether I had service. Let me look in the electronic
So,
file.
Judge, can I just interject something at the expense of trying to be transparent?
Sure.
We do have service. Your court officer, he didn't give me a proof of service, but he did give me a bill for his service. And I think the Phillips will attest to the fact that it was posted on the door.
All right, well, it's whether we have personal service or attachment.
Well, it wasn't personally served, I'm quite certain.
No, it says, I think it was served by attachment.
It was. And we did do the $13 mailing, which I think would obviate
second mailing.
Yep, which would obviate the need for personal service. But with all honesty, Judge, I do not believe that the extra mailing was done. What used to be done by, which we used to call the first mailing. Now I don't know whether it's the first or second, but only one mailing was done. So it was attached to the door and we did mail it. It was done. The $13 mailing was done.
But the court didn't do the second mailing.
That's correct.
So we're stuck with a continuance. Mr. and Mrs. Phillip, is she still there? You're on mute, I think. Ms. Phillip, I can't hear you.
You're muted. No, now you're muted. Something wrong with your audio?
They had audio before. Nod your head. Is she still there? All right, they believe she's vacated.
But I do believe, if I might, Judge, Rita, there still are possessions in the unit? Yes, okay. They've been gone for a while, Judge.
That was done.
Oh, all right. The clerk brought me proof that she did a second mailing.
Yes.
It isn't in the electronic file.
It is.
Oh, it is? Okay.
The
thanks.
second mailing was done, but Judge, I don't believe the first mailing was.
Well, this is sufficient for my purposes.
The first
Perfect.
mailing has to be done by the attorney.
Yes. So you didn't do the first mailing, you only did the second mailing?
Correct.
Yeah.
And they were served by attachment.
And they're gone.
And they're gone.
All right, I'm gonna do the default. Defendant has 10 days to vacate.
Perfect.
Now I ask you to send me a judgment.
Do you have one, Judge?
I don't believe so. Let me look.
And I know I should know this. My staff does. I don't. Are you an e-file court?
Well, what I'd ask you to do is email me a copy of the default judgment. They have 10 days from the day to vacate or the subject to being evicted. Today is the 16th of July. They'd have till July 26th to vacate.
I think that's a Saturday.
Yeah, I usually don't do things on a Tuesday.
I actually gave them, let's see, my judgment actually says the 28th and the computer pumps it out. So I'm thinking that the 26th is a Saturday. Yeah.
All right, it is. And I usually do these on Mondays and Fridays. All right. My email address is on the notice, but let me give it to you.
Thank you, sir.
3bcivil@stjosephcountymi.gov.
Countymi.gov. Will do.
And
That'll be as soon as I go offline with you. I will email this to you.
And I'll sign it. For you, Mr. and Mrs. Phillip, if she hasn't removed her stuff as of that date, July 28th, you can start to remove her property. And haul it away or set it aside. I'm not sure what kind of stuff is there. If it's junk, you can certainly haul it all to the dump. I'd suggest you change the locks on the property. Can take possession of it after July 28th.
Should Judge, we wait until we file a writ and you sign it?
Yeah, but I'll sign it. No, you don't, yes, all right. If they haven't vacated, they're subject to a writ. I guess if we want to be carefuler about it, it is a default, then you can get the writ on the 28th.
Perfect.
And then they can take possession.
My next question, I'm sorry, Judge, this is the first time I've ever been in your courtroom, so I'd rather be safe than sorry. Once you sign the order of eviction, does your bailiff come out and throw the stuff out, or does your bailiff come and watch them do it, or does your bailiff not come out at all?
No, our bailiff comes out. He's excellent.
Okay.
They sometimes do it in conjunction, but he will coordinate with the landlord. Often the bailiff comes out and they just put all the stuff out in the street like a garage sale. But very often the landlords just get a dumpster and clean it out themselves.
Perfect.
All right. I think I'm okay with that default with the second judgment or the second mailing and the defendant is not there. All right, well, if you come to Centerville or Minden, I suggest you do it in the summertime because there's not much to see here in January, but otherwise, I've been to Bingham Farm, so I got that on you, but maybe someday you'll get sent to Centerville.
And if I do, I'm going to try to make it during the work week so I can shake your hand. I've never met you before, and it's been a pleasure.
All right, thank you. I'll see you again perhaps.
Okay.
Mr. and Mrs. Phillip, good luck. Stay in contact with your lawyer.
Thank you.
Thanks. Rita, why don't you give me a call as soon as you get off of this, okay?
Yep.
Thank you, Judge. Have a great day.
We're working on it. All right.
Okay.
Thank you.
All right, now we've got a couple of Bradshaw cases and let's see who all is here. We've got the esteemed John Bradshaw. We've got Diane Coy, one of our tenants. We've got Kelly